First up, we have Registrar Kate Price. Registrar Price was recently appointed the Registrar of Probates at the Supreme Court of Victoria, having been appointed in December 2020. Registrar Price is going to discuss everything you wanted to know that's gone wrong about electronic probate in Victoria, but were afraid to ask. Now, when I became an associate to the judge in charge of the probate list in the Supreme Court of Victoria in 2012, Registrar Price was already the person to ask if you had a tricky or arcane question. It seemed that even then she had come across every problem that you could possibly have. So I'm very interested to hear in just what she has to say tonight with an extra 10 or so years of experience behind her.
Thank you very much, Paul, for that introduction. It was very kind of you to say nice words like that. I have been in the area for a while, so I've seen a bit of everything. But it's been very interesting, I think, in the last 6 months to be coming across these new types of wills, which are, of course, audiovisual witness wills that aren't informal. So it's been a very interesting time to be in this position of Registrar of Probates. Thank you also to EWOWC for inviting me to talk today. I think everyone would know that the court has been committed to a digital transformation both inside and outside the courtroom, which has most recently been seen with our launch of Redcrest Probate to enable the electronic filing of probate and administration applications. And I think that the progress that's been made in relation to that digital transformation across the board as a result of COVID-19 has been a really important step forward and something I hope will potentially stay around for a bit of time in some respects. Before I get on to talking a little bit about what I've seen in terms of audiovisual witnessing of affidavits and audiovisual witnessing of wills, I just wanted to give a little bit of an update on Redcrest Probate. The talk was perhaps a bit misleading because from my perspective, although I welcome the profession to correct me, but from my perspective, I think the online probate system, Redcrest Probate, has been an incredible success since it was launched on 1st of July last year. And we haven't actually had that many issues arise, which has been really good. I think going digital, there was a lot of concern in the community about what impact that would have. There was a lot of concern about what an electronic grant would look like and whether or not we would have asset holders recognise that electronic grant. But overall, we've seen some really good outcomes from the move to Redcrest Probate. Firstly, in terms of turnaround time. So previously, it took about 5 to 10 working days to get a grant from the court. Currently, we're under our new system, we're operating on turnaround times of about 1 to 2 days. If you lodge an application for letters of administration, most of you would know that you get that grant back the same day if you have everything right and you don't have any further information you need to provide to us, which I think is just incredible. I think when we built Redcrest Probate, it was really important to us to create a system that created efficiencies, not just a system that was easy to use, but that was efficient from both the user perspective as well as from the internal perspective. And a lot of people don't realise that along with creating Redcrest Probate from our end, we actually created a whole new system called the Examiner's Portal, which is what we use to actually examine the applications, to send out those requests for further information and to generate those grants. So that's what we did in tandem, is create those two systems so that we could end up in a situation where we got those really quick turnaround times of 1 to 2 days. The other really great thing is it has enabled electronic court files for judicial officers, which is really, really important. Previously, we used to be in a situation where if you filed an affidavit at 3 p.m. on a Thursday when your directions hearing is at 9 a.m. on a Friday, it might be that that affidavit might not actually get to the judge in time for them to consider that before the directions hearing. It still might not be time, so please don't take that as a suggestion that you should file affidavits at 3 p.m. on a Thursday when your hearing's on Friday morning. But the great thing is now that we've got electronic court files, so judicial officers can be assured that what they're looking at on their screen is exactly what's being filed with the court and everything is completely up to date. The other really good aspect of Redcrest Probate is that it obviously enabled us to do working from home arrangements during COVID-19. When we first had COVID-19 hit in March last year, we were still operating with paper files, and that was quite a challenge. It sort of involved a lot of couriers moving files from the court to people's homes and then back again. And it's interesting because I think now that we're online, obviously the examiners, the assistant registrars are able to work at home. One of my assistant registrars funnily said on the second day that we went live, I think this is the first time that probate has ever been granted from someone's garage. So it's been a really interesting time to be working through it. Just in terms of numbers, so far we've had 13,838 applications filed since 1st of July, and we've issued 13,178 grants. And we have had hardly any issues in terms of asset holders recognising those grants. And that's probably due to a lot of work we did in advance of launching the system, trying to get people, trying to get the banks, land titles office, those big sort of asset holders that a lot of people deal with when they get probate and administration. We got them on board and made sure they were aware of all the changes that were coming. So there hasn't been many issues in terms of asset holders recognising those grants, which has been fantastic. I think overall, not just asset holders, but the profession have adapted to that technology really well. They've adapted to being able to use Redcrest Probate and have found it fairly straightforward. There were some teething issues at the start, but I think now we're all in a rhythm. And I think overall it's been a really interesting time because there's been a huge need for the profession to adapt to new technology, not just Redcrest Probate, but obviously with the new introduction of legislation and regulations that allow for the audiovisual witnessing of affidavits, the audiovisual witnessing of wills. The profession was thrown into a situation where they quickly had to learn a lot of new software, a lot of new programs, and figure out how they would do that witnessing. I know that when this first happened, I sort of explored the idea of whether we could assist self-represented litigants by audiovisual witnessing of affidavits, and the technology was very difficult for us to arrange. So I can only imagine how much effort has gone into that by all of the solicitors firms that have adapted. Quickly, I mean, I'm here to obviously answer some questions later on, and I want to focus on that, but I just quickly wanted to talk about some of the things that I've observed in relation to audiovisual witness affidavits, audiovisual witness wills, to give you a bit of, I guess, some pointers about what to look out for and what to try and avoid in terms of audiovisual witnessing. Firstly, in terms of affidavit, I think the main issue that I've seen is that basically there's a lack of information in the jurat, which is actually required under the Oaths and Affirmations Act. So I would encourage everyone who's going to audiovisual witness and affidavit to double check those requirements in the Oaths and Affirmations Act and what you actually need to endorse in the jurat. Another problem that comes up frequently is that a lot of people state in their jurat that they're witnessing the affidavit audiovisually in accordance with the COVID-19 electronic witnessing and signing regulations. And that's not the case. You're witnessing an affidavit audiovisually in accordance with the Oaths and Affirmations Act. So it's important to double check if you do have precedents, what your precedents say, and that you're referring to the correct legislation in terms of what's actually empowering you to witness the affidavits in that way. In terms of audiovisual witnessed wills, which is what I think everyone is probably interested to hear about, so far we have had 7 applications filed with the probate office in relation to audiovisual witnessed wills. Unfortunately, none of those applications have actually complied with the regulations, and all of them have proceeded as on the basis that they're an informal will and will need to be assessed according to Section 9 of the Wills Act, which is a shame. But I think reading the regulations, there are quite a few steps that are required, and you sort of have to read through it a few times to make sure that you're complying with every single step. And if you are going to audiovisual witness a will using the regulations, it's really important, I think, you read through that and make sure you understand exactly what all of those steps are. Because if you do, I mean, the good thing is that we've got the remedial Section 9 provisions. So if it isn't witnessed correctly, then we can rely on Section 9 of the Wills Act to admit that document to probate as an informal will. But obviously there's a couple of issues with that. You're probably not going to have many issues in terms of proving intent because you almost got it over the line in terms of witnessing it as a valid will. So the intent issue is probably not going to be as difficult to prove as it would be if, for example, it was just a document that's been signed at the tennis by someone while they've been watching the tennis. But you do have the issue that if it becomes an informal will, you have to provide testamentary evidence. So you have to provide evidence as to testamentary capacity in relation to the testator. And that can be difficult if the person hasn't been assessed. All of the ones that have been filed so far, only one of them has been granted so far. The rest are still pending. And that's because the majority of times they're having difficulties with getting that medical evidence. So it is really important that you try and make sure that the will has been executed correctly. The other potential issue that you face is that you might be in a situation where it adds costs to the estate in relation to proving that will. Obviously, well, for those that don't know, the Registrar of Probates in Victoria has power under Section 9 to admit documents to probate if the value of the estate is under $1 million or over $1 million if there's consent of everyone who would be affected by a decision. But in any situations where it's over $1 million and there's minors or there's people under a disability, then that will have to go to a judge of the court for assessment. And that's obviously going to add time and delay in relation to processing the application and potentially going to add cost as well. So I think it's really important for anyone who's considering audiovisually witnessing a will to make sure that you're doing it correctly. In terms of what's been wrong so far, what I've seen and what I would suggest is probably the biggest, the two main things that have been problematic with all of the applications that have come through. Firstly, the majority of them, I think out of the 7, 6 of the applications that have come through didn't comply with regulation 41.5F. And that's the requirement that after the will has actually been witnessed by everyone, it goes back to the testator and the testator prints it out, for example, and actually endorses on it that it's been signed in accordance with the regulation and signs and dates that. And that hasn't been there on 6 of those applications. And it's really important that that's actually complied with. The other issue has been in relation to a bit of a weird wording in the regulations. And that is that the regulations require that an endorsement by each of the witnesses of a statement that it's been witnessed in accordance via audiovisual link. The thing with that is that it has to be, that statement has to be actually witnessed via audiovisual link at the time that the witnessing is done. So it has to be written at that time. And in a couple of instances I've seen, it's been endorsed on the will, but it's been endorsed there before the actual signing. So for example, if someone has been using DocuSign to actually witness the will, that statement has already been on the will before it's been provided to all of the parties to actually sign. And as a result, that's made it an informal will because it hasn't complied with the regulations. Now, I know that this seems like finicky little things. And I have had a couple of solicitors actually contact me and say, well, you know, can't you just overlook the fact that that particular regulation hasn't been complied with? But unfortunately, I don't have power to do that. The court doesn't have power to do that. We can't overlook the legislative requirements in relation to what constitutes a validly executed will. But as I said, we do have those remedial provisions in relation to Section 9, so we can look at it as an informal will. I guess what I'd like to finish off on, because I'm aware that we need to get to everyone else to talk to, and I will obviously answer any questions that anyone has. But what I would like to finish off with is just to give some advice. And that is basically that if you have audiovisually witnessed any wills so far under the COVID-19 regulations, please revisit those and please make sure that you have complied with every single step of those regulations, every single condition that is outlined in the regulations, and complied with it strictly, because that's what is required in relation to making sure that it's a validly executed will. If you have any doubt at all and the person is still able to, then I would suggest that you might want to contact your client and just potentially re-execute that will if you have any doubt at all about the validity of that will under the regulations. So happy to answer questions once we get to the end, but hopefully those few little things have been a few tips to look out for when you're audiovisually witnessing affidavits and wills.
Thank you very much, Kate.
Thank you.